and we will have time for questions at the end of the presentation. To ask a question, you can either use the chat function in Zoom, or indeed, if you would like to ask your question live, we will have that at the end of the presentation. So without much further ado, it's over to you, Rachel. Thank you.
Thank you so much, and thank you very much for inviting me to speak this afternoon. I've got a very fond association with ARU, and one of the things I do regularly normally is come on campus, but of course because of COVID that hasn't been happening. So I've been advising clients in the Anglia Ruskin Free Law Clinic, along with students who support that clinic. And Anglia Ruskin has also recently developed an app for litigants in person, and it was one of Anglia Ruskin's own students that worked on the app and on the questions in conjunction with the law clinic and the judges in the family court in Cambridge. And you will hopefully see when we go through my talk this afternoon why the work of the law clinic and that app are so important. Because people are finding themselves in very, very stressful situations and they cannot afford representation. So the work of the law clinic, as supported by the students and the university, is incredibly important. So without further ado, I was told that perhaps not many of you have studied family law, and so I thought that before I could talk about the impact of cost cutting on the family court, it would be important to tell you about the work of the family court. So the family court's a civil court where decisions are made by magistrates. They're members of the public who put themselves forward to sit at court, and then they receive some training. And they sit with a legal advisor who is a qualified lawyer and who guides them on matters of law, and by judges, some of whom are family practitioners before they come to the bench, and some of whom are not, but they all receive training in family law before commencing sitting on family cases. There are special rules that set out the powers of the court, so the magistrates, differing levels of judges, and the allocation of cases to them to try and ensure that cases are dealt with by a person with the correct level of expertise and expeditiously. So in other words, if there is a very complicated case, then that may be heard by a circuit judge. If there is something that's a little bit more straightforward, it wouldn't need to be a circuit judge, and it might be the magistrate's bench, or it might be a district judge. And the powers that those individuals have vary. Again, as you'd expect, a circuit judge has more powers than the magistrates. Now, the rules governing the procedure in the family court are called the Family Procedure Rules 2010, and they're based on the Civil Procedure Rules. If you've ever come across the White Book, the Family Procedure Rules are contained in something called the Red Book, and that's the sort of, if it's a hard copy book, that's the colour it is. These days it's now available online, and I have to say that for the sake of my shoulder and my muscles in my right arm, I'm very glad that a lot of things are now online, because the Red Book is actually quite heavy. So cases are decided with reference to a specific regime for married couples and civil partners, but not for cohabitees. And some of you who keep an eye on legal news will see that there's been a lot of campaigning to try and make the law for cohabitees on a par with those that are married, because society has changed a huge amount. Not everyone gets married. Some people live together for many years, and unless they specifically govern the legal relationships between them, then if they split up, that can cause a great deal of complexity and chaos. So for example, in relation to properties they may own, unless they actually set out how the property is owned, then the general law of property applies, and that can be very difficult for people. So there is a campaign to try and bring cohabitation law in line with the law for married couples. Other matters would be the welfare of children, adoption, guardianship, surrogacy, and to give protection from domestic abuse. And then more recently, legislation in the last few years was introduced to deal with forced marriage and FGM. So hopefully what you've gleaned from that whistle-stop tour on the first slide is that the family court does really, really important work, and it does work that involves fundamental issues in people's lives, matters which cause great stress and pain for people that can push them into having very different financial setups, whether they see their children and so on. So it's divorce, dissolution, and the consequences of that. Private children work. Now, private children work is disputes between private citizens, such as parents or grandparents. And when parents can't agree on how things should go, and everyone would rather parents could agree, but sadly after breakdowns of relationships sometimes they can't, the court will act as a third parent and make decisions about such matters as who children live with, where they live, how often they spend time with each of their parents, their name, their education, their medical care, and their religion. So you can see that these are massive issues, very complicated issues often, that need to be decided by the court. And you can also, I think, imagine that if you are to face that without representation, without a specialist lawyer, how incredibly scary that would be. The court also deals with public children work, so that's disputes involving the local authority who are responsible for the children in their area, and private individuals such as parents. So there could be a life-changing decision there. So a child might be removed permanently from the care of their biological parent. Similarly, the court deals with domestic abuse, so non-molestation occupation orders. So an occupation order, being aware that you're not family lawyers, is an order where a person who normally lives in a property is excluded from that property either completely or for periods of time, and that's a very draconian order. But the court can make that order, the family court can make that order where it considers it's necessary. And finally, child abduction, perhaps where a parent has taken a child out of the jurisdiction of England and Wales and is then refusing to return that child. So these are all very, very meaty emotional issues. So let's suppose that you are faced with a family law issue and you need to go to the family court for help. How do you fund that, the specialist help that you need? Well, some people are fortunate, they can fund that privately. They can fund it from savings. They can perhaps fund it from something called litigation funding, where let's suppose they are in dispute over finances related to divorce and they expect that the family home might be sold at the end of those proceedings and there's a considerable amount of equity in the family home. They can borrow against that equity to fund the litigation, although litigation funding comes at quite a high price and is often a very high rate of interest is often charged. So often people will prefer to borrow from their bank if they can, or pay for things on a credit card. In other areas of civil law, litigants can enter into a no-win, no-fee arrangement with a representative, but they can't do that in a family law case. It's not allowed. In addition, there's a general rule in children cases that there will be no order as to costs. So what that means is that in other areas of civil law, when a party loses, the winning party can ask for that losing party to pay their costs. In general, in children cases, that does not happen, with a very few exceptions. There will be some costs orders made in financial cases, but again, it isn't that usual. So the funding is actually quite limited even in the private sector, and publicly, a party might think, well, I could perhaps obtain legal aid or public funding. And in fact, every day of the week, Irwin Mitchell receives telephone calls directed to the family team where litigants are desperately inquiring if they are eligible for legal aid. So gradually over the last few years, cuts have taken place to legal aid. You can imagine that cuts were taking place, and then when austerity measures came in, further cuts took place. The most drastic of these cuts took place in 2012 and came into force on the 1st of April 2013. So the main act that makes these cuts is the Legal Aid, Sentencing and Punishment of Offenders Act 2012, which is known generally as LASPO. And that was designed to trim about 350 million off the annual budget for this kind of thing, but it actually reduced spending by more than 600 million a year. So it had a pretty drastic effect. Now, what kind of family proceedings is legal aid available for today, having had these cuts? The answer is domestic abuse, and that's applicants, not respondents. So that's the person alleging there's been domestic abuse. And clearly, as a result of public policy, the government decided it couldn't cut availability for alleged victims of domestic abuse. That needed to be available, so that's still available. Although I'll come to when it's available in a moment, 'cause it's not always available. Divorce, children and finances, if there's been an abusive relationship, forced marriage and public law proceedings. So you'll recall that that's where a private individual is involved in proceedings with the local authority, and family mediation. Now, even if you are alleging there is domestic abuse, you have to be able to provide some evidence of that. For example, perhaps GP records, police statements, etc. But as you can imagine, a lot of victims of domestic abuse don't press charges against their alleged perpetrators, because if it's in the family home, then first of all, they might be scared to press charges. And secondly, they will perceive that if the perhaps main breadwinner, and I don't want to stereotype, but sometimes this is the case, if the financially stronger party is charged with a criminal offence and convicted, then the victim of domestic abuse may be concerned that that will impact the earning capacity of the perpetrator. So quite often, victims of domestic abuse will make statements to the police and later withdraw them. Now, the police have gained the ability in recent years to bring victimless prosecutions and to apply for short-term domestic violence protection orders. But nevertheless, there are still victims of domestic abuse who do not, gather evidence that satisfies the legal aid application process. So there are still some victims who do not get the legal aid they require in order to go to court. Now, the other side of this, and it's not a very pleasant one, is that because if you make an allegation of domestic abuse, you might get legal aid if you can get hold of something to try and show are a victim. Those allegations have to be taken seriously, legal aid. And the problem with that is that then, of course, investigated thoroughly cost of the legal process. So let's suppose you have provided the evidence that's required in order to get legal aid, and it's the right kind of case that's still eligible. There is still a financial gateway to get through, and it is very narrow, and it's mainly those who are on benefits who will be eligible. So for example, if you own a home, even if you can't access that money, then you won't be eligible. And this has had a very serious impact on those on a low income who are in a trap where they have too much to get legal aid, but not enough to be able to fund really good representation. So already I hope you can see that access to justice for some people has been restricted insofar as their ability to be able to get advice at an early stage and get representation if they go to court. Now, just looking back a little bit, before LASPO, so that's the act that we talked about before, which was introduced in 2012 and introduced the cuts, 80% of applicants for legal aid were eligible. And now this is down to 33%. So not only have we reduced the types of case that legal aid applies to, not only have we raised the bar of evidence that you need, for example, in relation to domestic abuse in order to get legal aid, but in addition to that, we've got the financial gateway. So we've got a massive drop in those who make an application for legal aid and do not get it. So what is the result of all this? Well, it's pretty obvious. The result is that there are many, many more what we call litigants in person. So people without representation who are turning to places like the Anglia Ruskin Law Clinic for help, Citizens Advice Bureau, ringing up law firms and asking if they offer pro bono advice. There's also a unit which is attached to some courts called the Personal Support Unit, but they cannot offer legal advice. They help litigants in person, they support them at court, but they cannot actually offer advice. So the result of this is that there are now only 20% of family cases where both parties are represented by a lawyer. And in 35% of cases, neither has a lawyer. And you can imagine that for a judge or a court or the bench of magistrates, if they are dealing with a case where both parties are represented and arguments can be put quite succinctly and the order made by the court can be drawn up by the advocates afterwards, there can be some discussion before court and after court using the skills that the advocates have, that actually lessens the time that the case will take to hear in court and to go through the process. If neither party is represented, the case could take much, much longer. And that is in itself causing massive backlogs in the family court system. Because so many practitioners cannot now have a practice where there's legal, there are what has been described as deserts where in a certain area or a certain town, there are no legal aid practitioners available, even if someone is eligible for legal aid. So again, very difficult to make advice accessible for those involved in the court system. I'm just going to check my time here. So litigants are being asked to navigate a system which is actually designed for trained professionals. Now, remember, we talked about the Red Book earlier on. This is a book which, in fact, I may even have it here. I don't know if it can be seen. This is the Red Book. It's a jolly big book and it's small print. So litigants are being asked to navigate a system designed for trained professionals at what's probably the most emotional and vulnerable part of their lives, when their relationships are broken down, when they want to gain access to their children, when they want to work out how the assets are going to be divided when a marriage has broken down. And so you can imagine how difficult that is for someone going to court and dealing with that situation. So the result of this as well is there's been a rise of something called litigation or Mackenzie Friends. Now, the original Mackenzie Friend was in a case called Mackenzie, and it was a case in the 1970s where a person who was involved in litigation couldn't afford a lawyer, but had a friend who was qualified to practice law in Australia, but not in England. So he asked the court if his friend could come along and help support him at court and help him prepare for hearings. And the court gave permission for that. I must add that the family court is usually a closed court. It's not a public court where you can go and sit in the gallery. It's a closed environment where very private matters involving families are discussed. And so the court has to give permission for a litigation friend to go into court. Now, Mackenzie Friends or litigation friends are not regulated like I am. I'm regulated by the Solicitors Regulatory Authority, and I have a lot of regulations to comply with in my everyday practice, including having professional negligence insurance. Mackenzie Friends may be unqualified. Again, in order to be a solicitor, you have to have a minimum of 6 years training. And so you can hope that perhaps your lawyer is going to actually be able to advise you and be a specialist in the area you're consulting them in. They have no rights of audience, which means they're not automatically allowed to speak in court on behalf of the litigant, whereas all solicitors have rights of audience in the lower courts. And if you're like me, if you're a solicitor-advocate, I, in theory, have rights of audience all the way up to the Supreme Court. So what is happening in the family courts? Well, all of this means there are massive delays in the court system, as I said earlier, because cases without advocates take longer to process and there is more work for judges. In addition to that, there are other cuts to public spending which have exacerbated this. For example, the fabric of the court building. Now in Cambridge, we're quite lucky. It's a nice building, but there are other areas that I go to when I'm in my practice where there are no conference rooms. There's nowhere private. So if, for example, you request that you don't want to sit in the same seating area as the other person because you're alleging they have abused you, there's nowhere else to sit. It's extremely difficult. The courts are struggling, particularly at the moment with remote hearings, because they may or may not have the technology to do that. So that's to do with the court fabric and the support of the court. In addition to that, if a family who's involved in the court system needs intervention, such as therapeutic help, or from the mental health service, from CAMS, or family assistance orders perhaps, where a social worker can go in and provide more intensive support and help to a family, or expert assessment. So for example, if a psychiatrist or psychologist is going to meet with the family members and then make some recommendations about a way forward for a family, there's a lack of funding for that. And of course, families can't afford to pay for that themselves. Expert reports can cost thousands of pounds. Family assistance orders can cost lots of money if you employ a private social worker. And the result of this is very, very sad, because many parents may give up the fight, for example, for their children to spend time with them or to live with them. So before I come to what I want to say about pay now, cut now, pay later, what do I think needs to happen? Well, I think there needs to be a rigorous evidence-based study about the impact of the cuts to public funding, both in terms of legal aid, so that's money that pays for legal representation, and to the courts. Because you may have seen in the news, for example, and it's not just civil courts, but recently, following COVID, 10 temporary courts are going to be open to try and help clear backlogs. There's going to be one in Peterborough. But actually, over the last few years, 229 courts have been closed. So not only are there fewer courts, but they are absolutely rammed with people needing the intervention of the court. And so it takes longer and longer for that to happen, which can mean that it costs more money for that process. So I think there needs to be a rigorous study which assesses the short, medium and long-term impact on the well-being, mental and physical health and future relationships of parents and children who are involved in contentious litigation. Because there needs to be an assessment to the cost of future governments when the children of today become the adults of tomorrow. What do I mean by that? Well, if you've got a pot of money now which says legal aid, and you're very, very happy because the expenditure has been cut from down to 350 million, how much in today's money are we going to be spending in 20, 25, 30 years to deal with the impact of this on adults who then themselves become perhaps unable to form lasting relationships, who perhaps themselves struggle to be parents? Because unfortunately, sometimes when you've been involved in contentious litigation as a child and a very acrimonious breakup of your parents, it can cause problems down the line. And we are not doing enough now to try to help those children who, as I said, will become the adults of tomorrow. So finally, if I can get to it, there is really no better person, in my view, to quote in a family law context than Lady Hale, who you may be familiar with because she is has been the outgoing president of the Supreme Court. She was in charge of giving the judgment, which you may all have watched on television about Brexit. She was wearing her little famous brooch, and she said, the lack of access to legal services for some people who seriously need them in the areas which most affect their ordinary everyday lives, that is a problem. It's a particular problem in family law for all the reasons that I've just outlined. There was also a report from Amnesty in 2016, which said that the cuts to legal aid have decimated, so that's a pretty strong word, decimated access to justice for thousands of people. So in my view, these cuts will mean that society and individuals will pay later as the full impact of the lack of access to justice for parents and children and families is felt. Now, I was told that I should take about 35 minutes. I think I've taken 33. So I would be very happy at this point to open things up for some questions.
Thank you very much, Rachel, for a really thought-provoking and important discussion and presentation. Yes, so what I propose to do is, shall I stop sharing the screen and we'll have you back on camera?
Yes, I was hoping to come on. Yeah, there we go. I'm here now. See.
Brilliant. All right, so let's open the floor for questions. I already see some hands up. I'll be opening the floor in a moment. Ideally, for those who can, if you want to turn your, speak out your question, even turning your camera if you wish, that will give it a more personal feel. Alternatively, if you'd like to write your question in the chat box, I will be able to read it out for Rachel to answer. So, Rohan, I see you've got your hand up.
Hi, can you hear me?
We can hear you, yes. Thank you.
Hi, Rachel. Thank you very much for a very interesting presentation. I think you have demonstrated very clearly the issue with access to justice in the family courts and for litigants in person. In fact, my question is about litigants in person. I'm interested to know that judges are meant to be impartial, of course, but in your experience, how effective have you found them at guiding litigants in person in court itself?
I think, Rohan, that most judges are very sensitive to the problems that litigants in person face when they come to court, that they don't really know what's going on, the most basic things of where do I stand, how long will I be at court, and so on. And what I have found is if I'm representing someone and the other side is a litigant in person, my client tends to get quite fed up because the litigant in person takes, 30 words perhaps to say what I might say in a shorter time. So judges do listen on the whole to litigants in person and they give them that opportunity. I think judges are sensitive to that. The problem lies, though, in that there is only so much guidance that the judge, who, as you say, is impartial, can actually give to a litigant in person. A litigant in person might not even know what evidence is important to bring before the court. Quite often litigants in person will throw in the kitchen sink and literally 90% of what's there isn't really very relevant to the case. It is from their personal and emotional perspective, and I don't undermine that in any way. But hopefully a professional will be very selective. So yes, when a judge then has to come and read papers, they might be wading through a really long and quite untargeted, unfocused statement. Whereas if they get a statement in from a professional, that might be easier for them to read. So it is kind of inevitable that no matter how sympathetic the judge is and no matter how careful they are, the case is going to be much better presented, hopefully, by a professional. So I think it's a very difficult situation. And I think the worst situations are where there are two litigant in persons, in a way they're on an equal playing field and the judge has to kind of do all the work and explanations. Where one party is represented and the other is not, I would rely, I hope, on the professionalism of my colleagues to make sure that they don't try to pull any fast ones over litigants in person. And I certainly wouldn't. I'm an officer of the court, but I think it's very difficult for a litigant in person, for example, to take notes of a hearing whilst they're in a hearing. Often they're hearing quite, personal and difficult things coming into mind. They blank out what's being said. They can't always remember. They might get sent an order afterwards and they'll say, gosh, I didn't think the judge ordered this. Is this what happened? And I think that's really difficult. So I think short answer, I think judges on the whole are sensitive to this. But I still think that litigants in person have a pretty tough time in court, because it's really hard being there by yourself.
Thank you very much. Thanks.
I think Sarah had her hand up.
Aldo, you're muted.
Hello, Sarah. Do you want to talk?
Can I ask my question? Is it okay?
Yes.
Aldo, yes. So there was the review of LASPO in 2019, which didn't seem to really have any results as far as we could really see. But under that, government did undertake to work with the Law Society to explore an alternative model for family legal aid. Have you heard anything at all about that work being done? I mean, I know COVID's probably kicked that into the long grass, but I just wondered if it was anything that was simmering at all, or is it just something that's so easy to ignore?
I think that COVID and Brexit have stopped a lot of really useful work, and no, I haven't. No, I haven't, in short answer. The things I have heard about are the progress of the possibility that alleged victims of domestic abuse will no longer have to face questioning from their alleged perpetrator, which is something that, as you and I know, does happen in the family court and can happen. Judges try and avoid it happening, but in the criminal court can't. There's someone appointed to do that process. But no, I'm afraid I haven't. And in fact, it's sad, isn't it, that these sorts of things forever get chucked to the bottom of the list of things to do when they are so incredibly important.
And like you say, they're going to have a long-term expense to society and future government. Preaching to the converted here.
Someone else will have to pay out of a different pot, so why should I be worried about it now, is the attitude, I think, sadly. Aldo, is anybody else with their hand up?
What I was briefly saying while muted was yeah, so we just had two questions from Rohan and Sarah, both members of our advisory board. I have a question, unless I'll go with it. So perhaps if you could expand a bit more, Rachel, on the idea of saving now and paying later, particularly as you mentioned, given that saving now means raising more barriers to access to justice, perhaps dissuading litigants who might have a very strong case from pursuing that case, and how that could have the detrimental effect sort of down the line for society, for families, for communities more generally. If you could expand on that idea.
Yes, of course. So I think maybe if we take sort of anonymized case study, that might be helpful, which I'll extrapolate on. So let's suppose you've got a 11-year-old child whose parents separated 3 or 4 years ago, and who sadly have got a very, very acrimonious relationship. The child lives with mum, say, and spends time with dad, but actually the 11-year-old child is now refusing to spend time with dad. And the couple have been backwards and forwards to court. I think they're probably now on the 3rd or 4th set of proceedings. And the mum alleges quite a few things about dad. She might say that he hits the child, shouts at the child, cuts up their clothes that she sends with them, and so on. Quite extreme allegations that need to be investigated. And then following a fact finding, there might then be a social work report, a welfare report, Section 7 report we call it. And that report says, well, we can't find any, we think the child should spend time with dad, and there's an order made that should happen. Every single time that happens, the child should go at weekends to dad or whatever to go, they're frightened of dad, etc. And eventually their views will carry a lot more weight in the process. And it's very difficult then to try and force an unwilling child. Perhaps this is a boy, perhaps he's 6'2" by the time he's 13. He says he doesn't want to go and see dad. And mum says, oh, I told you, you know, dad's awful. And the result of all this is dad might have, if he could afford it, might have spent thousands and thousands and thousands of pounds on legal costs. If he can't, he might have done this by himself to start, you know, or might have spent money to start with and then turned into a litigant in person later because he can't afford it anymore. And eventually dad might just think, I can't carry on with this. It's so disruptive to my life. There's nothing we can do. There might even have been some therapeutic intervention. And that child might actually be alienated from dad. It's a very trendy word, but what essentially has happened is that the very negative narrative about dad that mum has given, which in this case, let's for the sake of argument say isn't true, the child has decided, look, I live with mum, it's an awful lot easier to go along with what she says. And at that point, there can be something that parental alienation psychologists call splitting. And the child thinks, you know, I can't deal with this, so I'm not going anymore. So moving forward slightly now to the child being perhaps 23, 24, and at that point perhaps having depression, maybe some addiction problems, issues with forming meaningful relationships. And I don't think I need to go on much more to work out that the impact that has not just on that individual, but on society, because there would then potentially be the cost for the NHS of providing mental health care and support for that person. They might not be able to hold down a job, so they may in fact find that difficult. They may enter into a number of relationships with people, and I'm not saying, look, I'm giving a very extreme example, but I think it's the way to look at it is that things that happen to children do impact upon them as adults. And so whilst we might have taken, you know, we've saved some money out of the legal aid and public funding of representation pot, later on the pots it might come out of are providing public housing to somebody who hasn't got a job, providing benefits, providing you know, mental health care. So that's what I mean by pay later, because actually it's all going to come out of the same pot. And I think it's incredibly short-sighted to take such focus away from the family courts. It makes me really cross. I think you can tell that I'm quite passionate about this subject. So does that help a little bit to give you that example?
Thank you. Yes, indeed, indeed. And as you say, your passion and also your experience in this area is really helpful. Rachel, let us take a last round of questions. So I see Rohan has his hands up. I've got another question myself, and if anyone else has a question, now is the time to you know, notify us. It's the last round. So Rohan, would you like to go ahead with yours?
Thanks, Aldo. Rachel, I'm so glad that you highlighted that little mini case study. It reminds me of a quote by John Milton from Paradise Regained, when he said the childhood shows the man as morning shows the day. And I really do think that family breakup of that type has enormous consequences for children later in life and society. I'd just like to focus on that, actually, on the access to justice point of it. And that is, in the event that police, for example, in your experience, fail to bring a prosecution, say, for example, in a situation where there's been potentially significant harm, and significant harm, is, I think, as Baroness Hale has indicated, is very difficult to define. It's like a spectrum. But in the event that perhaps the victim decides not, for the reasons that you've outlined earlier, to bring an action against the perpetrator, To what extent have you found that social services stepping in, for example, with child protection conferences and so on and so forth, and the whole procedure, if you like, in looking at the family and family dynamics, to what extent has that delivered some form of access to justice? It may not necessarily be in the breakup of the family, or it may in fact lead to social services taking the child out of the family or children out of the family or whatever. But to what extent, in your experience, has that been an alternative means of delivering some form of access to justice or not?
That's a very good question, Rohan. I think that the answer, as always, is it depends, and you can get some really good proactive local authorities or social workers who read the situation and intervene. And so for those who aren't as familiar with the sort of interventions, when someone's arrested for say assault, and there are children in the house, or it's a family situation, there are various forms that are completed, and a referral goes through to the children's services bit of the local authority, and that is then picked up by social services, and they will then perform a first sort of level of investigation about what's been going on at the house. And if they have concerns, safeguarding concerns, and again, for those who don't do as much family law, children don't have to witness domestic abuse, as in see it, for it to impact upon them. Obviously, they might be aware because they might hear shouting and so on, and there is much more awareness of that now. The social workers might, for example, designate a child in need, or, as you say, they might escalate it further to a child protection conference. What would tend to perhaps happen, and it's a bit of a blunt sword, there might be different levels of intervention depending on what's happened. So dad, let's suppose it's dad, and again, I don't want to stereotype, who perhaps is being violent, might be sent off on a course. Mum might be sent off on a course, so it tends to be the freedom course. With dad, it might be the course for the perpetrators of domestic violence. And if social workers feel things are changing, they might be willing to sort of cut back on their intervention. In a more extreme case, the parent the victim of domestic abuse, the parent who's abused, may say to her or him, look, if you carry on living with this person, the children will be removed from your care because you have a duty to protect your children and you need to take steps. And for example, they might say you need to make an application for a non-molestation order, an occupation order. So that might happen. Then, of course, that person might come under pressure from the perpetrator not to do that for all sorts of reasons. So there can be access in what you're saying. There can be a role for social services in that situation, which might lead to the sort of result you would hope, which is that children are not witnessing domestic violence on a day-to-day basis. But again, like anything else, there have been cuts to public funding. So some social workers who should perhaps be running a caseload of 20 cases might be running a caseload of 40 cases. So they might only focus on the very extreme, the very obvious, the immediate danger cases. And in fact, in the situation I just described as a case study, that wouldn't necessarily attract much interest from social services, because if there was not actual physical violence, despite the fact that, as we all know, domestic abuse is actually defined much more widely these days, so as controlling coercive behaviour, emotional, psychological, physical abuse, including controlling finances and so on, I think in a situation where there's nothing so obvious, social workers have got so much to deal with that they may in fact cut back their intervention quite rapidly, with the result that a situation continues to subsist with what you might call low level, although I wouldn't call it that, domestic abuse going on in a family and children continuing to be exposed to that. So yes, in extreme cases it helps, depending on the area, depending on the social worker, but it's certainly a bit of a blunt instrument, and it's not really the answer. The answer has to be that there should be an equal playing field, and that, you know, it shouldn't just be that you can pay to go to court to get things done quickly. It should be that everyone has access to that. So yeah, my view on that is it depends.
Thank you very much. That was an excellent answer. I learned a lot from that. Thank you.
Thank you.
Thank you. We've got time for just one brief question. I've got one, unless anyone else wants to, who hasn't spoken, would like. Okay. Rachel, my question very briefly relates to the current circumstances and the pandemic. You did mention how it has led to the postponement of some policy decisions, but in terms of access to justice, how now that we've been over 5 months in this situation, in the current circumstance, how has the pandemic affected family law matters and your experience?
Well, in the beginning of the of lockdown, there was chaos. Now it's a lot more ordered. So what is happening is that a great many hearings that are listed to take place are taking place remotely by telephone. And imagine if you're a litigant in person and on the other side there is a barrister or representative. Again, I think that must be quite overwhelming. So that's one thing. It's quite tricky on the telephone. It can be quite hard. Some hearings have been postponed, and the issue with that is, let's suppose it's a final hearing where the court is going to hear evidence from the witnesses and they want to be able to either see them in a kind of hybrid context or whatever. The issue there is that then the evidence that the court has got in front of it becomes out of date. And I've just had a hearing like that where by the time we were thinking of what we're going to do in the final hearing, the social worker's report and the witness statements very old and needed to be redone. So that's a difficulty, that the delays have then caused a domino effect. Certain courts are now doing quite well, I think. For example, in East London, they are triaging and cracking through cases. They've got some cases that their case number starts with the 2017 and 2008, and they're hearing those cases first, and they're trying to get rid of all those delayed cases. But it's not easy, and it has had an impact, and it's had an impact not just on the hearings, but on the work that experts can do with children. Because of course, a social worker who wants to, say, visit children in the family home, meet the children, meet the parents, particularly if they're quite young children or perhaps 6 or 7 years old, that's very difficult for them to do in this format that we're doing over Zoom, for example. They really do need to meet them in person. So there's been a lot of delays of reports as well. So there is going to be continued domino effect of this. It could go on for some time, but I think they've done pretty well on the whole. I'll give them that. They've tried very hard.
Thank you. And on that positive note, we're coming to an end of this webinar. But before we do, I would like to express once again our heartfelt thanks for this really informative, thought-provoking, and topical presentation, Rachel.
Thank you for asking me. I've enjoyed it too, so thank you.
Thank you. And with that, I'll bring to an end proceedings. Next week, we have the final webinar for this side of summer in relating to the judicial process in Canada. So if you can join us for that, that will be happening on Thursday at the same time, same place on Zoom. Thank you, everyone.
Thank you. Bye-bye. Bye.
Rachel.
Bye.
Thank you very much. That was really interesting. Thank you.